Hello and a warm welcome to this presentation. My name is Darren Murdoch. I'm a solicitor in practice with Waddell Mackintosh Solicitors in Troon. I'm also a council member with the Scottish Law Agents Society. During the course of this presentation, I will be discussing some of the more somewhat challenging and interesting executries which I have dealt with in practice. I will be discussing some of the issues and the solutions which I have applied. And hopefully, if you're facing a similar issue, you will be able to apply the solution which I will provide herein. In particular, I shall be discussing executries which have featured issues such as an alleged fraud by an attorney acting on behalf of the grantor of a POA. I'll be discussing an executory whereby the executors were at war, another case that was mandated to my own firm, and the appointment of the executors within the will was somewhat of a mess. I will look at a case involving domicile, another case that involved a solicitor wishing to charge in excess of £300 simply to sign a pre-prepared deed of declinature, to which my client took issue with. I'll be looking at a case involving an action for division and sale and another case involving the sum of £50,000 which was found in a suitcase. If I may start with the first of these particular cases, and this involves a case that arose from my time as a trainee solicitor. This was in fact one of my first ever executries which I dealt with. Now, I was concluding the executory. Accounts of charge and discharge had been sent to the residuary beneficiaries. They had signed and returned the accounts. I was in the process of making payment in terms of distribution of the net proceeds of the executory, when one of the beneficiaries approached my firm asking what had happened to the sum of £5,000 which was due to her daughter by way of a cheque written by the deceased individual. I examined the papers file and I noted that my predecessor had lodged a cheque in the papers file. I had omitted to find the cheque when I was looking through the papers. I examined the cheque and I noted that it was signed by my late client, but the content of the cheque otherwise was not written by my late client. It was narrated by a third party. I made inquiries as to the cheque and what capacity that the niece of the deceased had acted in relation to. Now, the niece of the deceased explained to me that she had acted as her late aunt's attorney in conformity with a power of attorney that had been granted by her late aunt. I proceeded to ask for a copy of the POA. I examined the same and I noted that the POA was in an old pro forma style that was available at the Office of Public Guardian. I also noted that the capacity clause within the POA was not signed by a solicitor, it was signed by a doctor. I inquired as to whether the niece of the deceased had advised the remaining family as to whether a POA had been granted by the deceased individual and whether the family had been advised of any key decisions in relation to the power of attorney. The niece of the deceased had stated that upon the grantor's instruction, she had not advised the family. I found the sum somewhat large in nature, and I was somewhat surprised that A, the niece hadn't informed the remaining family, and B, that the POA had been signed by a doctor without any further explanation. I examined the historic file notes and I noted that late client had attended our office with her niece to investigate matters in relation to power of attorney. My predecessor had quite rightly insisted upon a meeting without the niece being present. My predecessor had drafted a power of attorney had followed up and had not received a response from the elderly client. Now, before I go further, I would ask you to be mindful that during the lifetime of the grantor, the OPG has authority to regulate powers of attorney. That is to say, in terms of Section 83 of the Adults with Incapacity Scotland Act, a welfare attorney can be removed from office if they breach their fiduciary duty concerning the welfare of the grantor. Furthermore, in terms of Section 81 of the 2000 Act, an attorney can be removed from office and called upon to reimburse the estate of the grantor in terms of any misappropriation of funds. Now, that is only during the lifetime of the grantor. Being somewhat surprised at the amount of the gift that was granted to the niece's daughter, I made further inquiries. I approached the Bank of Scotland. I obtained 2 years' worth of account statements. I noted that in terms of the account statements, a blind 93-year-old had purchased a car from Arnold Clark. The 93-year-old had also purchased a new central heating system installed in the niece's house. The 93-year-old had an incredible social life in Covent Garden in England with countless ATM withdrawals. In total, I noted, in terms of the 2 years preceding the death of late individual, some £60,000 or thereby was withdrawn from her account by way of gifts or otherwise. I asked the niece of the deceased for a further explanation, and the explanation which came back was that the funds were gifts by her late aunt. Everything was a gift. It was with the consent of her aunt. None of these gifts had been afforded to the other residuary beneficiaries or other nieces or nephews of the aunt, nor had the other remaining family members been advised in terms of the gifts which had been forthcoming to the surviving niece. I advised the remaining beneficiaries in relation to the gifts, and before I could go further, one of the beneficiaries was so irate she contacted the police, and as a trainee solicitor in first year of practice, I was interviewed at length by the CID. I found this a very, very worthwhile and informative meeting, even though it was 3 hours with the CID. CID investigated further. They went back a number of years, and in terms of their reckoning, they thought that 175,000 or thereby had been misappropriated from my late client's estate. They made their report to the fiscal. The fiscal examined the case and decided that it would not be in the public interest to proceed. The remaining beneficiaries were annoyed at the decision of the fiscal, as was the CID that investigated the case. I advised the remaining beneficiaries that they were entitled to independent legal advice, and I looked at the possibility as to whether they were seeking to raise a civil action. They decided to simply draw a line off under the matter. They did not wish to pursue an action for account of reckoning in terms of the niece of the deceased. Nonetheless, this was a valuable learning experience for any trainee or solicitor. From this particular case, I soon realised the value of the initial client meeting and advising the client of the gift clause within the power of attorney, and that they should not incorporate a gift clause unless they implicitly trust their nominated attorney. I also advised the client to inform their attorneys that they must keep a set of accounts in terms of their intromissions in relation to the POA. I'm very careful in dealing with executory estates whereby a POA has been active. And this particular case left somewhat of a sour taste in the mouth, for the OPG has no authority in law to investigate the affairs of a deceased individual. The OPG only has statutory authority to investigate the welfare of a grantor and the continuing nature of a POA of the grantor during the lifetime of the grantor. Somewhat unfortunate, because a number of frauds are not uncovered until a third party, such as an executor, is involved. Nonetheless, this was a valuable learning experience in relation to that particular power of attorney. Okay, the next case I'd like to look at is one whereby a file was mandated out to my firm. I examined the will, and the executors clause reads as follows. I appoint as my executor my husband, the said Ian McGlumford, whom failing by death or incapacity within 1 calendar month of the date of my death, my son Ian Duncan McGlumford residing at. Now, as you will appreciate, this clause has the capacity to cause issue. And in this particular state, it did cause issue, because Mrs. McGlumford passing away, she was survived by her spouse, Ian McGlumford. He was incapacitated, and he survived her for 4 months. So therefore, in terms of the will, Ian McGlumford Jr. was not entitled to be appointed in terms of the executor clause within that particular will. Now, the solution was to be found in the Executors Scotland Act 1900, section 3 thereof. And I proceeded to appoint the surviving son, Ian McGlumford Jr., qua residuary legatee in terms of section 3 of the 1900 Act. Now, the surviving spouse only survived for a matter of 3 or 4 months, and he also passed away. So in terms of the confirmation applications, I sent them to the local sheriff court simultaneously. I put a covering letter in. I appointed the surviving son as executor of his father, qua residuary legatee in terms of section 3 of the 1900 Act. I also appointed him as executor of his mother by virtue of the fact he was the representative of his father. The sheriff duly granted confirmation in both estates, and I proceeded on that particular basis. Now, another case that has relied upon the Executors Scotland Act of 1900 was whereby a retired solicitor was seeking to charge the sum of £350, as I recall, simply to sign a pre-prepared deed of declinature. This was to the utter annoyance of my client, and in terms thereof, they asked if I had a solution. Now, I examined the will. I noted that the executor was named in the will, and he was not authorised in terms of a separate clause allowing him to charge a fee. Now, I thought that he was being somewhat unreasonable in terms of his charges. I wrote to the court seeking to appoint the surviving family member as executor in terms of section 3 of the Executors Scotland Act of 1900. And on the basis that they were qua residuary legatee, I also informed the court that my client was of the opinion that the solicitor had acted doctor in rem sum, or that is to say, they breached that particular principle. They were not entitled to charge for their services, and the court duly granted confirmation on that basis. Now, the next case I would like to examine is one that involved conflict. And as we are all aware, in terms of the solicitor's regulations, and as expressed in Patterson and Ritchie, law and conduct for solicitors, we cannot act in conflict. Now, I met with my clients in the reception area of my firm, and immediately I noted that there was somewhat of an unusual atmosphere. I introduced myself, I started the meeting, I explained the initial correspondence that had to be sent out. The son of Mrs. McGlumford remarked that that was an effing challenge and a half, because he knew enough to have the effing son of his sister locked up because of his actions. The reply forthcoming was, "That is effing rich coming from you, for I know enough to get you locked up." Now, I was somewhat taken aback by this. This wasn't your usual initial executory meeting. Right away, I knew that I could not act for both of these individuals. I would have refused the instruction had they both insisted upon remaining as executors to their late mother's estate. I would add that a sole executor cannot resign office. Therefore, I proposed that one of them could resign office and I could take instruction from the other. If they were not agreeable to that position, then they could assume my trustee company as an executor and thereafter both resign as executors. I also stated that they could either leave having got nothing whatsoever from the meeting, or conversely, they could let me take charge of the meeting, not address one another unless the necessity was there, and if they were to address one another, they do it in a manner in which they would like to be addressed themselves. I concluded the meeting. I advised that they were both entitled to take independent legal advice. I advised that I could not act and was not willing to act for both of them. I reminded them that one of them could resign office if they so choose to do so, and I left it in the client's hands to revert to me. I received a call the next morning from the daughter of Mrs. McGlumford. She profusely apologised for her behaviour, and she informed me she did not wish to take up the role of executor. Shortly thereafter, I received a call from the son of Mrs. McGlumford, and not surprisingly, he also profusely apologised for his behaviour the day before. I advised him that his sister had beat him to it. She had already resigned as executor, and he stated he was willing to act as executor on that basis. Now, I appreciate we're sometimes called upon to make decisions, without warning, but I'm also, from that meeting, I was afforded a reminder that there's sometimes that you just don't want the business. Some business is not worth having. And had they both insisted upon being appointed as executor, that is one particular case I would have refused to act in relation to. Okay, this brings me on to my next case, and that is concerning the issue of domicile. I would stress that it is very important that not only ourselves are aware of the law in relation to domicile, but also that our support staff and our secretaries are aware of the law concerning domicile. The reason I bring this up is because I was in the room adjacent to one of my support staff. She received a call from the friend of a late client notifying us of the death. I heard from my colleague that the family would need to instruct an English solicitor because the late client died in England. At that point, I went through to the room, I took over the call, I asked some further questions. I was informed of the background of the late individual, and he moved to England owing to frailty and ill health some 2 years prior to passing away. Circumstances were such that Mr. McGlumford retained his will with the firm of Waddell Mackintosh and Troon. He retained a boat in Troon Harbour. He had a son north of Inverness. He had a son in England, and he had another child Firth of the United Kingdom. In terms of that particular executory, I narrated the declaration, giving the background to the late Mr. McGlumford. And in terms of the declaration on page 2, I stated that he had no fixed domicile, except to say the same was in Scotland. I submitted the application to Edinburgh Sheriff Court, and confirmation was duly granted. Now, that particular estate was in excess of a 5-figure sum in relation to our fee, and if I hadn't have taken that call from the support staff, that particular executive would have went elsewhere. If I can add another part of that executory, the late Mr. McGlumford was an absolute hoarder. He rented space at Kilmarnock Removals, and when I started the executory, I received sackfuls of correspondence. I can tell you that Scottish Power did not charge a standing daily charge in the 1970s. Reason being, I have seen utility bills from 1970 with that late client's estate. His brother predeceased him. A lot of the paperwork was in relation to his brother's estate. Being diligent, I searched through the paperwork and I found a post-it note with a sort code and account number on it. I tracked down the fact it was an Aviva account. I wrote to Aviva with the death certificate of my late client and his predeceasing brother. Aviva wrote back to me stating that there was £57,000 in the account, and it was my late client's account, not his predeceasing brother. That sort of is a sort of learning point, how important it is to be so diligent when dealing with executory estates. On that note, I have also ingathered funds from the Prudential that should have been paid out in the 1930s. Over the last year, I have ingathered £50,000 to £60,000 in dormant accounts from banks. I dealt with an executory estate whereby I wrote to Bank of Scotland with 3 account numbers. They wrote back in relation to 2 account numbers, no mention of the third. I visited my local branch, found out there was another 2 accounts with some 50,000 or thereby within the further accounts. So banks do sit on top of hundreds of millions, no doubt billions, that should have been distributed to executory accounts, and you have to be so observant and careful in terms of dealing with executories. And as I say, in terms of the domicile issue, I would advise that you ensure that not only yourself is up to date with issues concerning domicile, but also your support staff. And your support staff, if they're assisting you with the executaries, you inform them of the need to be diligent in relation to administering the estates of a late individual. Takes me on to a case whereby myself and my colleague were informed of the death of a late client. His family were somewhat estranged. They advised us that they were of the belief the late individual held the sum of 50,000 or thereby in a suitcase in his flat. Myself and my colleague attended the flat. We done a search in terms of the belongings, and sure enough, we found a suitcase, and there was indeed slightly in excess of £50,000. We made a report to the DWP and the National Crime Agency. Interestingly enough, I think my client had an aversion to paying nursing home fees, for I noted that he had some 26,000 in his bank account, and the threshold is 26,500 or thereby in terms of being self-sufficient in relation to your own nursing home fees. I went back to the flat and I found another 2,000 or thereby. So from that particular estate, I learned of the value of attending in twos. And there are some executory estates whereby, you sometimes need a witness, and it's appropriate that if you come across such an unusual case, that you take the necessary action, that you report matters to the DWP, and you complete and submit a National Crime Agency report. Okay, this takes me on to my last case, and this was a case that involved two executries. Mrs. McGlumford and Mr. Smith get together. Mrs. McGlumford purchases a heritable property. Mrs. McGlumford and Mr. Smith agree to a minute of agreement whereby the estate of Mrs. McGlumford will be furnished with the sum of £28,000 from the sale of the heritable property, and anything left over will be split equally between the two estates. Mrs. McGlumford passes away in 2006. In terms of the minute of agreement, Mr. Smith had a right to reside in the property. My firm administered the executory estate of the late Mrs. McGlumford. We were not appointed as executors. When Mr. Smith passed away, his daughter took issue with the competency of the minute of agreement. She challenged the minute of agreement, and we took an advocate's opinion in relation to the minute of agreement. And in terms of moving forward, the executor in the United States dug her heels in. She wouldn't consent to the sale of the heritable property if the minute of agreement was insisted upon. We obtained confirmation, and we notified the executor in the United States that our firm, in terms of our appointment as co-executor, would be applying for confirmation unless we heard from her within 14 days thereof. Nothing further was forthcoming. We also advised the executor on the other side, prior to the initial stages of our father's estate, that there was a likelihood of conflict in this particular instance, and that she should take separate legal advice, and that we could not advise her, nor could we act for her, if she considered that there was indeed a conflict. At the end of the day, confirmation was granted, and despite confirmation had been granted, the co-executor decided that she would not sign in terms of any disposition. As such, I raised an action for division and sale after my trustee company resigned as a co-executor to her father's estate, and I raised it on behalf of the executors of Mrs. McGlumford. Now, the executor of the late Mr. Smith's estate resided in New York, and as such, I had to serve him with the initial writ and the citation in conformity with the Hague Convention. That is to say, it has to be served by recognised international agents, utilise the services of ABC Legal in the United States, and it has to be delivered to the defendant in compliance with a USM 94 or 96, it'll lose me which of the two it is. We had a certificate of attestation from the serving agents in the US, and despite this, the solicitor acting for Mrs. Smith lodged a reporting note at Ayr Sheriff Court. Now, the outcome of this particular case was settled in the corridors of the court. I negotiated a settlement with the representative of Mrs. Smith, and I negotiated the settlement on the basis that the children of the late Mrs. the grandchildren of late Mrs. McGlumford were entitled to a legacy to Mr. Smith's estate. I knew that the grandchildren would never see such a legacy unless a minute of agreement was put in place. So we resolved the case at the end of the day, but this was an interesting case. It involved issues concerning conflict, and it also raised the question of an action for division and sale of a heritable property. I'm going to go into more detail in relation to that particular case in a forthcoming presentation. It's not something that we deal with ordinarily, but it's something that is worthwhile knowing in terms of how to proceed when you reach stasis in an executory. I thank you for taking the time to view this presentation. Now, you are entitled to a half hour of accredited CPD. I would ask that you email the Secretary of the Scottish Law Agent Society, that is Mr. Andrew Stevenson. His email address can be found on the SLAS website. I would simply ask that you drop Andrew an email confirming that you've watched the presentation and that you answer the question of, in an instance whereby you're instructed by the family of a deceased individual, you peruse the will and all the executors are either deceased or incapax, please advise how you would proceed on that basis. Thank you very much.